So I think two things that have come from what you are saying is that one is the kind of non-representative, exclusionary nature of the bench, right? So that doesn't reflect the social diversity. That's what. I think the other thread that I thought I found interesting was also you mentioned that which actually touches on the concentration of powers in the hand of one person or few, right? So, and because as we know, the smooth functioning of a democracy is in the strength of the checks and balances, right? So now in this case, in the Justice Karnan, that particular standoff, now you find that the institution which is actually, chiefly responsible, I would say, to look into this, or function as the checking balancing institution, is itself now in turmoil, right? As a lawyer, as a person who is also part of this system, so how do you see now? What are the steps forward, or how would you think this could have played out differently? In this particular scenario, and what is the
how do I look at the Justice Karnan's case? It's a very peculiar case for me. A man belonging to scheduled caste from the Tamil Nadu, who was an activist and who was seeking the relief of justice, who was seeking equality, who was seeking fraternity to all, was elected to the High Court as a judge, where he found that the judges themselves are being discriminated on the grounds of caste. But the one person cannot be enough to plead down that discrimination, to annihilate that discrimination based on caste. One judge will not be enough because he will be lacking a strength, and more or less he will be a junior judge for many years to come until his seniors are retired. He was, I think, supporting it because of caste discrimination, and it is coming out in media and also coming in the conversation. I would judge like you see, he wanted to bring equality in appointment process.
Okay.
First thing he found that the collegium system, which is recommending only the few caste judges or few caste people, men's, is not functioning in accordance with the spirit of the Constitution. Actually, the spirit of the Constitution, what I want to tell to everyone of my listeners, that the spirit of the Constitution was first argued by Babu Ambedkar himself before the Supreme Court. So Justice Karnan must be thinking that the collegium appointments are not in accordance with the spirit of the Constitution.
So he had questioned.
Yeah. Okay. Then he must have found that the few caste men appointed as the judges are mostly engaged in corrupt activities. It is his insider's view. It may not be true.
Yeah, it's a perception.
It is his perception. And he found that the few caste main judges are engaged in corrupt activities, in appointment of judges, widespread favoritism, appointment of subordinate court judges. And he must have feel like the discrimination in assignment of rosters to the judges, because that Chief Justice does. See, I tell you, if a man who became a judge from scheduled caste develops a perception that he is also being discriminated, then it is like it is like a very difficult situation for such a man. Either he would become a rebel, or he would quit the job. I understand that the Justice Karnan became rebel.
Okay.
I feel he became rebel. And as like an Iron Man, he wanted to change the whole system in a day. So therefore he was complaining complaining to many authorities, complaining to Chief Justice, complaining to various authorities including Prime Minister, so that some relief should be there. He was complaining of his own Chief Justice, and then because of that the tussle broke out between the Supreme Court Chief Justice or maybe the High Court Chief Justice and himself, which has I think resulted into a very deep-rooted prejudice by the other judges.
There is also
It is a provocation to the deep-rooted prejudices, and